Thank you everyone for joining me today on this first webinar in our new European PROPcast series. And our webinar today is part one of a two-part webinar where we're going to be looking at key points when taking a new lease of commercial office space in Germany, France, and the Netherlands. In the 40 minutes that we have today, we're going to look at, first, what investigations, if any, should a tenant carry out before it agrees to enter into an office lease? Secondly, what are the usual costs when you enter into an office lease? Thirdly, what rents are payable and when are they payable? Fourthly, what is the usual length of an office lease in our relevant jurisdictions? And are there any restrictions on this that a tenant should be aware of? We're also going to look at if the tenant has any rights to terminate the lease early. And finally, does the tenant have security of tenure, by which we mean having the right to remain at the property, even though the contractual term of the lease has expired, and usually to request a new lease. So first of all, some introductions. My name is Lisa Scharfenhorst, and I'm the consultant trainer here at Evershed. To answer my, and hopefully all your questions on the office lease in the various jurisdictions, I'm joined by Sebastian Woschek from our Munich office, Virginie Essuie from our Paris office, and Annette Relou from Amsterdam. So welcome to all of you, and thank you very much for your help today. I should say that we are going to focus here on taking commercial office lease in a major city in the relevant jurisdictions I've mentioned. So really we're talking about Berlin, Paris, and Amsterdam, where of course the demand for commercial space is high and landlords do have a strong negotiating position. To aid in our comparison, I'll also talk about what happens with London office leases, since a number of you will be familiar with that market. But of course, it is worthwhile mentioning here that if you are to take a space, out of these major cities, it of course may result in the tenant having a stronger negotiating position and you being able to agree a more tenant-friendly lease. Let's start then with the usual first steps when taking an office lease. Let's assume that you as a client with your agents, where applicable, have identified some fantastic office space within an existing commercial property and you want to take a lease of that space. Now, if that space were in London, then as a solicitor acting, I would have to carry out an extensive title investigation to check that the landlord owns the property, is able to enter into the lease. There's nothing on the title that would affect the tenant's right to use the property. I would also check that planning permission was in place for your proposed use. And finally, I would have to carry out searches to check that there was nothing that would affect your use of the property or could cost the tenant money. I'm now interested in finding out what investigations my colleagues would carry out in their relevant jurisdiction. So, Sebastian, if I may start with you, if the office space was in Berlin, would you be carrying out similar investigations to the one I just mentioned?
Well, Lisa, no, actually I would not usually carry out any detailed form of title review or investigation of such kind. The German principle of abstraction, the so-called Abstraktionsprinzip, actually allows the landlord to rent out the property even if he is not registered to own the property or registered as the owner of the property. Under German law, one of the landlord's cardinal duties is to hand over the property to the tenant as contractually agreed. And if the landlord fails to do this, then the tenant can claim damages. If the tenant has some concerns about the landlord's ability to deliver what he has contractually agreed, then of course we may take further steps in terms of title investigation, but however, for office leases especially, this is not usual.
And Sebastian, is planning covered within this principle? Would you not carry out checks that the property can be used for the tenant's proposed use, or would that also be covered?
Yeah, so we would also not usually carry out a planning check. So the cardinal duty of handing over the space as contractually agreed means that the landlord, in fact, is fully responsible for providing the tenant with the property which is fit for its use. If it is the case that the property is not fit for the contractually agreed use, then the tenant can, for example, reduce the rent, claim damages, or even terminate the lease agreement. Of course, for some tenants, this ability to claim damages or to terminate does not provide sufficient comfort, especially in large build-to-suit logistics leases, where damages or right to rescind would not mitigate the actual operational losses of not receiving a permit, for example, then more due diligence would be carried out, and we would review and check if the realization of the project is possible at the chosen property, including planning permissions, noise and traffic studies, utility service, and so on.
Okay, fantastic. Thank you, Sebastian. Virginie, if we go over to you in Paris, what would be the position be if our office lease was in your jurisdiction?
Well, like in Berlin, in Paris, the tenant would not usually carry out a title investigation. You know, the landlord guarantees the use of the property, and it's part of its obligation. So the confirmation provided in the lease is sufficient. If the tenant cannot use the premises for its activity, then the tenant is entitled to terminate the lease and to obtain damages. By the way of example, we had a situation where we discovered that the premises rented by one of our clients for office spaces included residential spaces. We took this advantage to claim that the lease was void and to negotiate a rent-free period for our client. In addition, the landlord had still to make sure that the use of residential space was changed into office spaces. And to tell the truth, it's quite challenging in Paris.
Thank you for that, Virginie. An interesting example there. Finally, Annette, over to you. What investigations would you carry out if our office lease was in Amsterdam?
Well, Lisa, in the Netherlands, the situation is similar to England and Wales in that the onus is on the tenant. The aim is to first verify that the landlord is entitled to rent a property. Secondly, to check whether the intended use of the property could be restricted in any way by civil law and/or public law restrictions. We would also check whether any third-party consents, for example, of a mortgagee, would be required before the landlord can enter into the lease. In addition, we would also usually carry out a zoning plan survey to ensure that the intended use of the property is permitted under the applicable zoning plan. A permitting survey may also be recommended to assess if the proposed business activities of the tenant will be subject to special permitting or notification requirements. Depending on the location and the previous use of the property, we may also advise our client to carry out an environmental survey. Depending on the outcome of these surveys, we may also include an allocation of remediation costs in the lease.
And Annette, since you, I think, in the same way as in London, have a great deal of title investigation work to do, how long would it usually take for you to carry out those investigations?
Not that long, actually, because, as most of the required information is available online, the initial investigations will usually be completed on the same day. If, however, on the basis of the initial findings, additional research or surveys would be required, this would of course take more time.
Yeah, okay, fair enough. Thank you for that. We've looked at title investigation, so let's move on to our next point, which is one I'm sure you're all interested in, which is what are the costs in each jurisdiction associated with taking these? Obviously, it's usual that clients want to know what costs they'll be incurring in taking an office lease. So let's have a look at those now. And Virginie, if I may start with you, what are the costs associated with taking an office lease in Paris?
Well, you know, Lisa, in France, there is always something to pay. So it's very often the case that at the signature of a lease, the tenant pays a rent deposit when it's applicable, the first rent amount, the agent fees, and in addition, tax and cost of publishing the lease if they are also payable. Concerning the publishing cost, it will depend on the length of the lease. First, if the term is equal or is less than 12 years, then the publishing is optional. But we recommend highly to publish the lease since it ensures that the lease is binding to the successive purchaser of the premises. The cost is only 25 euros. And second, if the lease term is more than 12 years, which is not really usual for office spaces, then the lease must be received by the French notary and published at the land registry. In this case, the publication costs are much higher, and it's approximately 0.7% of the total amount of the rent and the charges during the whole length of the lease. It is very usual that in Paris, the tenants pay all these costs.
Okay, good to know. Okay, and then what's the position in Amsterdam? What fees would the client be looking at paying to take an office lease in Amsterdam?
Well, in Amsterdam, there are no taxes or registration costs that are payable, though, of course, the parties may have agreed for the tenant to provide security for its obligations under the lease in the form of a cash deposit or a bank guarantee. A tenant may also have to pay an agent's fee, depending on whether or not the client has instructed the broker to conduct the negotiations with the landlord on its behalf. The only other costs involved would be legal fees, but these will vary on a case-by-case basis, depending at which stage the client gets us involved in the negotiations, the number of document turnarounds, and also the type of lease. It's important here to mention that in the Netherlands, most leases are based on a format developed by the Dutch Real Estate Council, or in Dutch Raad voor Onroerende Zaken, in short ROZ. And this so-called ROZ model is considered to be the Dutch market standard. Where possible, tenants should insist on this form of lease being used, since negotiating a new lease on the basis of this so-called ROZ model is more cost efficient than drafting and negotiating a lease from the ground up.
I have to say, Annette, I'm very glad that you had to pronounce the ROZ definition there rather than me. But on a more serious point, Annette, there is a very important point here on leases in the Netherlands and instructing you early on, isn't there? Because there's something here that could significantly catch a client out if they're not aware of it.
Yes, well, I guess that most lawyers would suggest instructing us early on in negotiations to reduce costs overall. But in the Netherlands, it is particularly important since it is possible by entering into a letter of intent to then be obliged to negotiate and actually enter into a lease. This is because of a Dutch principle of pre-contractual good faith, which, if not dealt with correctly, may result in a party having to pay damages that it may not be expecting.
Okay, so just an important point there. Obviously, if you are dealing with leases in the Netherlands, to make sure that you consult the lawyers very early on before you enter into any sort of letter of intent, to make sure that you're not inadvertently becoming bound to something that you're not expecting to be bound to. Over to you then, Sebastian, and thank you, Annette, for raising that important point. If I may ask you, Sebastian, what sort of costs are we looking at when registering or dealing with a lease in Germany?
Well, the good news, Lisa, is that there are no taxes or registration costs connected with entering a lease in Germany. The only costs the tenant will pay will be for legal advice on taking the lease, brokers, of course, and but these will all be assessed on a case-by-case basis. It's also worth noting here that most commercial lease contracts in Germany need to be physically signed on an original, the hard copy, so to say, and there can be some logistical costs and also potentially delays when circulating the lease and getting it signed by both parties. Just by way of an example, one of our build-to-suit leases we recently signed, the only way to really make sure to meet the timeline was to get the managing director signing on time was to send the originals via a direct motorcycle messenger from Munich to Prague, where the signatory had a short stopover with his private plane and could then sign the originals just on time. So these are the costs that might need to be considered, but no registration or notary fees of such kind. Yeah.
Okay, fantastic. And thank you for that, because it is always interesting, I think, in each jurisdiction as to what signatory requirements are required. I know that US clients often expect to be able to sign things remotely, and of course in some jurisdictions that's not possible, so thank you for raising that point as well. Of course, when we're talking about costs, the main costs that the tenant will be considering as well will be paying the rent for the premises. And obviously it's probably worthwhile pointing out here that in London, if we were to take a lease of an office space in London, there will be three types of rent. principal rent being obviously the main amount that's payable, insurance rent, and also service charge. Principal rent is payable usually quarterly in arrears, insurance rent is payable on demand, and service charge is estimated and paid quarterly in arrears, but with the potential for a balancing charge at the end of the calendar year. It's also worth noting that rent in England is often, not always, but often increased every 5 years to make sure the landlord continues to receive a market rent. If the market rent falls, however, the rent under the lease is not also reduced, so it's an upwards-only rent review. The question that I have to you guys now is, how is rent calculated and paid for in your jurisdiction? Are there any key points here that a tenant should be aware of? If I can start with you, Virginie, what's the position in Paris?
So in Paris, the tenant pays, of course, the rent, the operational costs of the building, the tax, including the land tax, and the insurance of the building. So the rents are usually paid quarterly in arrears, and as in London, charge and taxes are rebalanced at the end of the calendar year or at the beginning of the following year, and this on the basis of the real cost paid by the landlord for the services and for the tax. As regards regular rent increases, lease in Paris has always have a CPI provision under which the rent is reviewed every year automatically and in line with an index, which is mentioned in the lease. And for office spaces, it's the ILAT index. It's a new index, and since this index is in place, we have never experienced a decrease. So in practice, the rent is always going up.
Okay, thank you. And then if I can come over to you in Amsterdam, what's the position from a Dutch perspective?
Well, in the Netherlands, rent will be calculated on the basis of the rent per square meter and the amount of square meters of lettable floor area, as well as to the extent applicable, the number of parking spaces and the services which will be provided by or on behalf of the landlord. It's customary to index the rent on a yearly basis after the first year of the commencement of the lease. In almost all cases, indexation will only lead to an increase of the rent. A tenant may propose to stipulate that the indexation amount will be kept, for example, by including a provision to the effect that an index over a specific percentage will only be partially implemented. Rent in the Netherlands is usually paid in advance, monthly or quarterly.
Thank you very much. And Sebastian, if we can go over to you with the same question.
Yeah, so in Germany, it's actually quite straightforward. There's a base rent, which can be agreed freely between the parties, and which is mostly paid on a monthly basis on the third working day of the month in advance. The rent can only change if this is provided for explicitly in the lease agreement, but for long-term lease agreements, the rent is usually connected to changes of the German consumer price index, which means that the rent can technically also go down as well as up. Alternatively, the parties could, however, also agree on a stepped rent, which would then increase by, for example, 2% every year. In addition to the base rent, the landlord will also charge for operating and ancillary costs. The lease needs to specify in detail and in a transparent manner which charges will be made for such costs. There's a monthly advance payment of these costs, but at the end of each year, will be accounted for and invoiced, which leads to a surplus being paid back and/or deficit claim in case of anticipated when agreeing on the level of advance payments on these operation and ancillary costs.
Thank you for that, Sebastian. I think it was clear that maybe that's something that people didn't like to hear there, because you went slightly off on your signal slightly cut out. I'm hoping that will be fixed when you come to speak to us again, but if you can step nearer to the phone or what we can do to try and hear you as clearly as possible, but I think we caught most of that. The next question I have, which is to go on to, is minimum and maximum length of leases in your jurisdiction. So I know in England and Wales that there's no minimum or maximum lease length, but that leases are generally kept fairly short, with an average lease term of around 7 years. Sebastian, what's the position in Germany on lease length?
Yeah, so in Germany there is no minimum length to a lease, but there's a maximum fixed term of 30 years. If the contract is entered into for a period of longer than 30 years, for example 40 years, each party has the right to terminate the contract so that the contract ends at the end of the 30th year in that case. This is, however, usually not an issue since in German leases, they do not tend to be concluded for such a long period.
Perfect. Thank you for that. We could hear you clearly, so that's good. And over to you, Virginie, in France. What's the position in France on lease length?
So in France, the parties will execute a so-called commercial lease on office spaces. They have a minimum length of 9 years, and at the end term of the lease, the tenant has a kind of security of tenure. By security of tenure and on satisfaction of certain conditions, the tenant can remain in the property once the original lease has contractually come to an end. It is also
Virginie, is it? Sorry?
Yes, it is possible to execute a shorter lease. And for example, one of our clients wanted a lease of only 2 years, and so we recommended to them to execute a derogatory lease, which is a lease of 3 years or shorter. And concerning this kind of lease, there is two main things to remember. Unlike the commercial lease of 9 years, the tenant does not have a security of tenure at the end of a contractual term. And secondly, the maximum length is 3 years, so it means that the party cannot have a 3-year lease once and renew it, or to have multiple leases with a total length exceeding 3 years. If they want a lease with a length superior to 3 years, then they have no choice to sign a commercial lease.
Okay, thank you for that. And Annette, finally, the same question over to you.
Yes, Lisa. Well, in the Netherlands, the parties may agree on any term for a lease of office space. The lease may be entered into for one or more fixed terms or for an indefinite period of time. Security of tenure is not applicable to this type of lease, although a tenant will be protected against eviction. This means that a landlord has to serve an eviction notice in which the tenant is given 2 months to vacate the premises. If, however, the landlord fails to serve such a notice, the tenant cannot be forced to vacate the property even when the term of the lease has expired. Just to note that for retail space, which, well, obviously we're not covering in this webinar, but I just want to mention this, the regime is much stricter. Tenants will enjoy security of tenure, and the mandatory lease term with a minimum of 5 years with a 5-year extension will apply.
Thank you very much. Thank you, everyone, for that one. And a related question, I guess, looking at the length of a lease is what rights the tenant would have to terminate the lease, since the tenant might agree to take a long lease on the basis that they have a break right or an ability to terminate the lease. And I just wanted to check what the position is in each of your jurisdictions on termination rights, obviously for a tenant to terminate the lease earlier than the contractual term. So, Annette, if I may start with you, what's the position in the Netherlands?
In principle, early termination is not allowed unless the lease includes a specific tenant break option. If such a clause is included, then usually the landlord will stipulate that the tenant is obliged to pay an agreed termination fee. It is possible to have a fixed lease with extension options. Depending on what is stipulated in the lease, after the initial term has lapsed, the contract will either terminate automatically, unless the tenant has invoked this extension option, or the lease will be extended automatically, save where the tenant has validly served the relevant notice within the agreed notice period. The most common and preferable option is an automatic renewal. It's also possible in the Netherlands to have a lease for an indefinite term, in which case the lease may be terminated by giving a termination notice. The period of notice will be specified in the lease and will usually relate to the applicable term for the rental payments. For example, if rent is payable quarterly, usually a 3-month notice will be agreed. If annually, then a notice period of 12 months will be usual. Please note that parties are free to agree as they wish on this.
Okay, thank you very much. And over to you now, Sebastian. Would you mind telling us about tenant break rights or termination rights in Germany?
Yes, of course, Lisa. So where the lease has a fixed term in Germany, then the lease term cannot be terminated early and is binding on both parties unless special termination rights or break options have been contractually agreed in the lease agreement. For example, in office leases, break options are quite unusual and often connected to quite a high penalty payment for early termination if included. It therefore strongly depends on the negotiation power of the tenant and also the market situation, but it would not be unusual to request 50% or even more of the rent the landlord will not receive due to the early termination. Where, however, you have agreed on an indefinite commercial lease contract, each party can, unless otherwise agreed, terminate the lease by serving a termination notice to the other up until the third working day of a calendar quarter, and this notice will then terminate the lease at the end of the next calendar quarter. So if the termination notice is received, for example, before the 3rd April, the latest, the lease would end on the 30th of September. If it is received too late, for example, on the 4th of April, then the lease would only end on the 31st of December, which is then the end of the next calendar quarter. So it can be terminated on a quarterly basis.
Fantastic. Thank you, Sebastian. Over to you, Virginie. What's the position in Paris on this?
Well, like in Germany or in Netherlands, in France, the lease cannot be terminated earlier by the party, but there are two exceptions. The first one is concerning the fact that the tenant has a break option by law at the end of each 3-year period upon given notice to the landlord a 6 months prior termination notice. And the second exception is, of course, when the tenant has break option on a date mentioned in the lease and if the party derogates to the termination rights specified by law. Just a quick point here. When serving a termination notice, it is highly recommended to use a bailiff to ensure the legal certainty of the notice, and it only costs 200 euros, excluding VAT. I've got quite an example. Once of our clients missed the date concerning the delivering of the termination notice, and it means that he was bound for another 3 years. Thankfully, we were able to introduce a new tenant to the landlord, and we negotiate an early termination of the lease for our client. But you have to be very careful with the date.
Yeah, I can imagine that's quite an important point. And Virginie, on the right that the tenant has to terminate the lease by law at the end of each 3-year period, is it possible for the landlord to exclude that right?
Yes. It is possible for the party to exclude the termination rights, and obviously, if the landlord has a strong position, he will use it to exclude this right. Because, landlords usually look to do so to secure the rent and for a longest period. I should also mention the fact that there is also a limited right for the landlord to terminate the lease on the expiration of the 3-year period in several hypotheses, but this is very rare, and it's when he wishes to build or to rebuild premises. Where this right is exercised, however, the landlord has to pay an eviction indemnity to the tenant, or he shall provide new property to the tenant. At the end term of a lease, if the tenant does not wish to remain in the property, well, he shall serve a termination notice by bailiff, and this at least 6 months before the end of the term. Otherwise, he will remain liable to continue or to pay the rent under the lease.
Okay, thank you very much. Our final question today concerns what rights the tenant has to remain in the premises once the contractual term of the lease has expired. And we've already touched upon the fact, Virginie, that in your jurisdiction, tenants do have security of tenure. Would you mind just providing us a little bit more information on that?
Well, as you noticed, and as I said, the tenant has a security of tenure when the contractual end of the lease. And so this means that the lease is not terminated. If both the landlord and the tenant remain silent after the contractual end date, then the lease will continue under the same terms and conditions. We call this period the tacit prorogation. I have often tenants in Paris coming us near to the expiry of their lease, and they're asking me what I should do. Unfortunately, there is no one answer to this question, since the action to be taken by the tenant will depend on the action taken by the landlord. You know, in France, it's like a chase game, so it's a bit complicated to explain all the possibility. Then, of course...
So sorry, Virginie, I was going to say, but what you have done here to help those people who have more interest, because as you say, it's quite a complicated topic where, you know, there's a lot of law involved, there's a lot of different permutations involved as to who does what when in order to, you know, the landlord requesting, the tenant requesting a lease, the landlord looking to terminate. There's quite a lot going on here. So it's impossible in such a short webinar to spell it all out, but you have put this on the slides and presumably would say anybody interested in leases in your jurisdiction, whether or not they have security of tenure, to speak to you to get more information on what the process might be.
Yes, and so always remember that each case is specific and needs a specific advice, and timely legal advice should always be taken.
Thank you for that, Virginie. As I say, it's a reminder that security of tenure does apply to certain leases in France. As Virginie said, do feel free to contact her for specific advice. It's obviously very much on a case-by-case basis. We will, of course, circulate slides after the webinar, which will provide you a little bit more information on the renewal process. We thought it was important to put something out on the slides here so you have an overview of it. But as I said, it's a little bit too complicated to go through on the webinar today. Sebastian, if I can ask you, is there any security of tenure, any such concerns in Berlin, in our office lease in Germany?
Thank you, Virginie and Lisa. No, in Germany there's no such thing as a security of tenure for commercial tenants. Once the contractual term ends, the tenant must vacate the property. If a contract is entered into for a fixed period of time and there are no renewal rights, then it ends when it ends, so to say. However, the parties can agree to prolong an existing lease agreement by entering into an addendum to the lease contract in which they can agree on a different term, for example, make it shorter or longer as the case may be. It is also quite common to give the tenant the unilateral option to prolong the lease already in the lease agreement. So, for example, 10 years of a fixed term with 2 additional options for the tenant to prolong the lease by another 5 years each. So, for example, a 10-year lease is granted with 2 5-year options, and then this would, if the options were exercised at the discretion of the tenant, give the tenant the potential of having a 20-year long lease contract.
Fantastic. Thank you, Sebastian. And over to you now, Annette, in the Netherlands. What's the position on security of tenure for office leases in this case in Amsterdam?
Yes, thanks, Lisa. Well, like in Germany, in the Netherlands, there's no security of tenure for office leases. The only protection that a tenant has at the end of the contractual term is that the landlord also has to send a notice of eviction to the tenant, which will usually be sent together with the termination notice. Unless such notice is served, then the tenant can remain, but it will have to pay a fee for the extended use of the property. If such notice of eviction...
Sorry, Annette, you just broke up there and we got to the notice of eviction. Would you mind just saying again? So I got to the point that when the termination notice to terminate the lease, it's usually sent along with the notice of eviction. Would you mind then just telling us what happens if that notice is then presumably not served?
Oh, okay. Yes, I'm sorry about that. I was just saying that unless such a notice is served, then the tenant can remain in the leased property, but it will have to pay a fee for the extended use of the property. If such a notice of eviction is sent by the landlord at a later date, that is not simultaneously with the termination notice, the tenant will have, from the date of the eviction set forth in that notice, 2 months to vacate the premises. I would like to note, however, that the tenant is not entitled to a suspension of eviction if the tenant has given notice of the termination of its own accord, or if the tenant has expressly agreed to the termination, for example, by entering into a termination agreement with the landlord, or if the tenant was ordered by a court to vacate the premises because of default.
Okay, so that gives the tenant a little bit of flexibility. I expect that they can then remain within there if the landlord doesn't serve a termination notice for a period but continue to pay the rent as normal. So as you said, there is a process in place to make sure that the lease can then be terminated.
Yes.
Well, thank you, everyone. I mean, that's all that we had to deliver today. Thank you, everyone, particularly to our lawyers here on the call today from our various jurisdictions. If you did have any questions, then please do feel free to drop a line to our various advisors. We've put their details here on the slide here at the end, so you can obviously contact those directly. Apologies to Sebastian there, that should say Principal Associate. I didn't mean to demote you, I've just forgotten to update that slide there. Please also join us next time when we're going to be looking at various other points on our second webinar. We're going to be looking at how a tenant exits the lease, other than by way of assignment or subletting. Obviously we looked at termination, but obviously other ways by assignment or subletting. We're also going to look at how to ensure that you have rights to use areas outside of the demise, outside of the area let to you, but within the building. We're also going to look at what protections you need to rectify any problems within the building, of which obviously the property is a part, how to limit the landlord's rights over the property, and finally, what rights you have or need to have in order to alter the property before and during the lease. I should also say that this is the first of these sessions, so if you do have any feedback or comments on today's session, then please do let us know. We're very happy to have your input. If there were any areas that we didn't cover or you thought it was too short, too long, then we're very grateful for your feedback on today's session. And as I say, it will only help us to improve webinars for you going forward. With that, I'll leave our details of our legal advisors, again with apologies to Sebastian, and say thank you very much for joining us today. And thank you for your time. I hope you enjoyed today's webinar, and thank you very much.